Good morning.
Good morning, Chief Justice Marshall, and may it please the court. My name is Robert Shaw.
You didn't get off to a good start.
I'm sorry?
Good morning, Chief Justice Marshall.
That's okay.
Chief Justice Ireland.
She's with
My
us in spirit.
apologies.
That's all right.
I'm
been here
going
too
back
long.
to an earlier time. Chief Justice Ireland, and may it please the court. My name is Robert Shaw. I'm privileged to appear today on behalf of Lamourie Gray. There are many issues in this case. My intention this morning is to get to the failed identification of Jamison, hopefully the rap video issue, and issues surrounding the gang evidence. And with respect to Jamison's failed identification, I want to be sure that there is no confusion here regarding what was really a critical sequence of events that gave rise to defense counsel's repeated request that he be able to introduce Jamison's failed identification. Because from the very beginning of trial, it was the government that wanted to rely on Jamison's alleged excited utterance identification, knowing that he was unavailable. Now, initially, defense counsel opposed that. Then, during the course of trial, defense counsel acquiesced, and they got what they wanted. And it was defense counsel's expectation, which I would suggest to you is in accordance with common sense and basic fairness, that he be able to respond by introducing evidence that Jamison failed to identify Mr. Gray before the grand jury and picked out a different person. The judge refused, and then even when defense counsel sought to attack or question the credibility of Jamison during his closing argument, he was shut down. And when defense counsel then asked that the judge limit the consideration of that excited utterance, given the fact that he was unable to attack his credibility, the judge again refused. Now, this gives rise to three challenges. Each have independent legal grounds. And I want to begin by pointing out that this is an error of constitutional import, and it is an error of constitutional import for three reasons. First, again, emphasizing a very important point here. It is the government that sought out and relied upon the statement of an unavailable witness. And so fundamentally, this issue before the court is about the right to respond. This alleged excited utterance relied upon by the government as a central component of its case was 100% about identification. And identification was the sole issue in the case. And because failed identification was the sole issue in the case, this was exculpatory evidence, and it was essential to Mr. Gray's defense. Now, the government has come back in its papers, and they're essentially saying to the court, well, you know, we have other evidence, and we believe that we would be able to persuade the jury, and we believe that, court, you should believe as well, that Jamison's not credible. His inability to identify Mr. Gray was intentional. We believe we could show that. Well, my response to that is more power to you.
Could I just interrupt you? I've looked at the grand jury materials.
Yeah.
Could you point out where it is that he fails to identify in the grand jury?
Well, you have to look in my record appendix. It's been
Okay.
provided in my record appendix
Okay.
where he fails to identify him and testifies with respect to that.
Okay.
But again, my response to the Commonwealth is essentially, you have your version. We have our version. You cannot rely on a central component of your case to convict him in a legal proceeding and then say that he does not have the right to respond. Now, separate and apart from these constitutional issues, the right to present a defense, the right to confront, we have also raised the fact that there is a right to impeach. There's a right to attack the credibility of Jamison. And I ask you to simply look at the case of Commonwealth versus Marr and Rule 806. You know, that principle is right on point. It says that when the government relies on the out-of-court statement of an unavailable witness, a defendant has the right to respond in any manner that would be permitted were that witness to appear and testify, regardless of whether the government has a later opportunity to respond further. So I urge the court to simply rest on those principles.
But originally,
am I correct that you weren't really arguing? I looked at the citations that you have in your brief to the record. They don't, you indicate should support your request for this information on impeachment grounds. But those citations really only refer to your earlier motion, which I think was limited to an inconsistent identification, not the impeachment or
Right.
consistent or something. I mean, it wasn't you didn't really make an impeachment argument, did you?
Well,
I mean, you suggest that you did, but I don't see that you did.
the initial motion begins, and it's in my record appendix, with saying we have the right to confront identification evidence. It talks about exculpatory evidence. It talks about the right to present a defense. So all of those are consistent.
So the specific item that you wanted to introduce was not look at the grand jury testimony. That wasn't it. It was limited to.
It was limited to the fact that he was provided with a photo array and he identified the
It
wrong
was
person.
really just the photo, wasn't it?
Yeah, he identified the wrong person. He did not have the ability
It
to
wasn't
recognize.
the grand jury testimony. It was the photo array.
It really wasn't the grand jury testimony.
Right.
It was
separate.
It was separate, and it was the photo array. It was contained in the grand jury testimony, but that's where it occurred. And I think if you again, the sequence is very important because that motion that you're referring to, you have to remember, that was argued before
Right.
later in the trial when it turned out that, okay, we're going to rely on this excited utterance identification. It's going to come in substantively, and the government is going to rely on it as a central component of their case. So at that point, counsel's saying, wait, hold on a second. I have a right to respond to this. At this point, you may have denied this motion earlier, but at this point, I've got to be able to respond. And it's true that he doesn't cite Rule 806, but it's clear that what he is saying is I have the right to respond. And I would also note that in the case of Commonwealth versus Marr, the defendant didn't specifically cite Rule 806. Now, another basis is, if you look at this as former testimony, there are two things that make very clear, I think, that our position is the correct position here. And that is when you look at the cases cited in the briefs by both parties, you will see that when former testimony, grand jury testimony, is at issue, those cases look and use as a primary role whether the testimony was central to the case. Okay? If you look at the McFall case, the Foster case, the Miller case, all of those, the testimony was central. The refusal to allow it in was considered error. Even the case that the government relies on, United States versus Omar in the First Circuit. If you look to page 522 of that case, the First Circuit begins its analysis by saying, were this central to the case, we would reverse on that ground. So clearly, in this case, this evidence, this former testimony, if that's the way we want to characterize it, is central to the case. A further distinction that mandates a finding of error is that in every single case, I believe it is every single case cited by both parties in both briefs, it is the defendant who wanted to rely on an unavailable witness through grand jury testimony to bolster the defense case. In this case, it is the government who relied on the unavailable witness, and it is the defense who sought an opportunity to respond. So I do understand that the Commonwealth has filed a late motion. I filed a response because I'd like the court to know what I think of that. I think it is an excessive request. In any event, I think that it demonstrates the point, which is that clearly the prosecutor had motive here and he had opportunity. Opportunity has to do with the fact whether when witnesses were live during the grand jury, the issue was live at that point in time. Motive has to do with the issue that the grand jury proceedings concern, and clearly that's identification is the case. That was the issue there. Now, moving on, unless there are any questions, to the rap video issue. As an initial matter, I've gone to quite extensive lengths to try to convey to the court some understanding of rap music, assuming, which may be wrong, that you don't have that already. And the reason for that is that when you have some understanding of the music and that genre, You understand that the normal rules of interpretation don't apply. We don't say that looks like X, therefore that is X. We don't say that anymore in this area of entertainment or artistic expression than we would in any other area of entertainment or artistic expression. We don't say that somebody appeared in some form of artistic expression and therefore they're making a statement or a declaration of their own facts.
Well, doesn't it speak for itself?
I don't think it speaks for itself, Your Honor.
Let's not talk about rap music for a moment, but just for music in general, do we need experts to interpret a song to jurors, or aren't they able to apply their own common sense, their understanding of words and melody and all of that to reach their own conclusions?
Certainly they can, but the point is that those who are participating, Lamoury Gray, because he's in the background, he didn't write the song, he didn't produce the song. The fact that he participated in the minimal way that he did does not mean that he is making a statement of fact and intention about himself.
And what was the purpose for admitting, I'm certainly going to ask the Commonwealth, the specific purpose for admitting the video?
Was supposedly to rebut defense counsel's change of strategy, where they say that all of a sudden he changed his strategy and was trying to assert that there was no gang connection. Now, he didn't...
So does this video establish a connection between the defendant and other known gang members?
Well, I mean, does...
A visual, a picture,
Well,
doing stuff together?
well, yeah, I suppose so. I suppose so. Does it, ultimately where they try to get with this is, does it provide motive and intent to kill? That's really what it is, right?
Well,
And
step
that's
by
the-
step by
Well,
step.
no, isn't
Step
it?
by step.
Well, it's step by step, but that's the end point. But let's assume for a moment
Why
that...
isn't it impeachment evidence?
Impeachment of what?
His distancing himself from gang membership.
He didn't distance himself from gang membership. I mean, that's clear. I mean, defense counsel made it absolutely clear. Defense counsel in his opening statement conceded it. Now, is it true that we dispute it? Yes. But having lost the motion in limine, defense counsel did what he should have done, which is say, well, if you're going to allow that extremely inflammatory video into evidence, I won't contest it during the trial. And he didn't. In fact, he came out in an opening statement and he conceded a connection with the Heath Street group.
So explain to me again the context in which this was admitted. It was admitted on redirect examination, right?
It was admitted because defense counsel asked a single question about a photo, and
It was a photo of an array that depicted people with gang affiliation, and your question sought, as I understood it when I read it, to say, well, actually, when did you take it? Wasn't it on the day of the arrest or something like that? Or something to suggest that there wasn't a long-term affiliation, it just happened to come up on that day. Wasn't
well,
that the
actually,
point?
that morning they had arrested Mr.
Right.
Gray, and they had woken him up out of bed, and his hair was somewhat messy, and he was trying to establish a time element to that particular photo. Mm-hmm. But it was absolutely clear throughout, I mean, overwhelmingly, that he was not challenging gang membership. He asked no follow-up questions or anything like that. And there was an easy way to dispose of the issue if, in fact, the Commonwealth needed some way to respond.
But you made this argument to the trial judge, and the trial judge, or not you, sorry, the generic defense counsel, made the argument to trial judge who determined that, in fact, it was opened, the door was open to this evidence, based on that exchange regarding the photo.
Right. Right. Now, let's assume, for example, that the video comes in, as it did here. I mean, really cutting to the chase and to the core of the issue, the question is, what was it probative of? I mean, Lamoury Gray, this was a song that was uploaded to a promotional site for this kind of music. It featured two artists who do music. Heat Life Entertainment put it out with Straight 8 Money Records, and they put out music. Lamoury Gray didn't write the song. He didn't produce the video. I mean, it was a promotional video. The video was downloaded by the police sometime in 2005, so it was created obviously before that, perhaps up to 1.5 years earlier before this murder took place. So how is this probative of motive and intent to commit a murder a year and a half later? And this video did not speak of a particular feud. The prosecutor says, oh, this was a pledging allegiance to a gang. Pledging allegiance to a gang? That's not what gangs do. They say, you want to be a member of a gang, you've got to make a music video with us. That was something that was made up.
Can I just ask this? I couldn't understand a single word of it, just because maybe the audio wasn't good enough. Was there a transcript of the lyrics?
No. And again, and now moving on to why it was so enormously prejudicial. Very inflammatory. You've got the word nigger stated repeatedly, which is very offensive. Words like suck me off, swallow my kids, then it's back to the strip, I got drugs to pitch.
Those are the things I couldn't hear.
Smoking marijuana. They're smoking marijuana. There's discussion about, okay, so this is going to be very inflammatory. Very inflammatory. What was this probative of outweighing that sort of inflammatory prejudice? And I asked the court to compare this with the cases cited by both parties in terms of rap lyrics or rap music coming in. And I've cited a study which demonstrates that this is extraordinarily prejudicial. Finally, with respect to cases involving motive, I understand that motive does not need to be conclusive. But just look at the cases cited by the Commonwealth, the Wetchell case and the St. Germain case. In those cases, you have a defendant and a victim who had certain interactions with one another and shortly before the murder, and that provided the motive. So there was some intertwining taking place there. Here, we don't have that at all. Now, turning to the gang issues, one of the reasons that this is of such import is because the standards being used by the Boston Police Department are being adopted in our courts of law as a threshold for what a prosecutor can assert and say to a jury. This case isn't about someone filing a lawsuit because they've been put in a database for living in an area and being seen with people on 2 occasions or more. This is about standards that have been translated into assertions about a specific person in a criminal case. Now, I'm not saying that the government cannot make allegations based on gang evidence and say that you have motive and intent to kill based upon your gang membership. The question is, how do you get there? And do you get there based pretty much on association alone? Look at the Boston Police Department standards for a gang and compare it to the other standards used by other states. A gang can consist of any 3 or more individuals who identify in some way, including a common name, color, or symbol, and frequent a particular area. Well, any group can be identified as a gang. In fact, this court can be identified as a gang. You frequent this area, you all wear black robes. Now, you might say to me, well, Mr. Shaw, that's ridiculous. We don't engage in criminal conduct. Well, that's my point. This definition doesn't require criminal conduct. That's the problem. They are looking at certain characteristics and saying, this person lives here, we've seen him with these people, we're going to call them a gang based on this association. And then this gets translated in a criminal proceeding to you have the motive and the intent to kill. And that is a real problem.
So take a step back here for a second and just explain this to me. So the witness who testified to this was qualified as an expert in gangs, right, and in Boston gangs in particular. And what you're saying is, A, he was not qualified, or B, the standard he used is not sort of recognized in the industry, let's put it that way.
Well, if you compare this to other states, just as a general matter, other states, and you look at the definitions provided in the Commonwealth Record Appendix, either through the definition of a gang or a gang member, they require some conduct, okay, criminal conduct. It's not just based on association. I'm not going to get into a quarrel about Detective Sheehan's qualifications. I don't think I need to. It's basically the standard he's applying to say gang member and to pin this label, a status, and then to utilize that status to make very, very prejudicial assertions in the midst of a criminal trial. The other problem, of course, and by the way, I think the court can cut through the complexity and the problems here simply by requiring that there be evidence of conduct. If you are going to say this person is a gang member, this person takes on the gang's pursuits and interests and motives, then you have to have some defendant-specific conduct. And of course, the other issue that came up is a lot of this testimony of Detective Sheehan was hearsay. It was insulated from verification and confrontation. If you look at the charts that I've provided, he admits that it's based on conversations. We don't even know what the conversations are. We don't know when they took place. We don't know who provided them. And there's no way to attack this. There's no way to confront this.
Thank you.
Thank you.
Good morning, Your Honors. May it please the Court, Chris Foster for the Commonwealth. With me are the trial prosecutors, Masai King and Craig Iannini. To address the defendant's first issue, the prior recorded testimony, the defendant's fundamental flaw here is that his argument's already been rejected by this Court only 3 years ago in Commonwealth versus Clemente. The defendant's essentially asking this Court to find that there's always similar motive between grand jury prosecutors questioning in the grand jury and at trial. And this Court flat out rejected that, saying it would be a very difficult burden for the defendant to sustain because the Commonwealth must have the same motivation to develop fully. And here I think it's clear from the grand jury transcripts and exhibits the prosecutor didn't have the same motive because he was going to prove the falsity of this identification and did. He started by disproving that Cliff Mangret, the person who Chris Jameson identified as the Maury Gray, by disproving that he was the Maury Gray.
But why isn't this all played out in the context of the trial? I mean, you've got this excited utterance that comes in. Why doesn't the fact that he misidentified the defendant come in, and then you put your evidence in that was a false for the following reason? I mean, why isn't that kind of important to play itself out in front of the jury?
I think that was in Judge Gaziano's discretion to prevent essentially a trial within a trial.
But you were really depending on this spontaneous utterance.
Correct.
And now you have an unavailable witness. You're depending on this spontaneous utterance, which was a little bit at the margin. And how is the defendant to rebut that?
Well, to begin, the defendant's not disputing that it was a spontaneous utterance, and he didn't really dispute it at trial, regardless of whether or not it happened immediately before the shooting or immediately after. But I think the problem here is the defendant would have to...
But the spontaneous utterance is essentially, oh, that's so-and-so, but then the grand jury, he misidentifies that person, says that that's somebody else.
Correct, and I think the fact that it would have very little probative value, the fact that it was very clear from the grand jury testimony that Chris Jameson was lying.
Well, that's a different question, though. Isn't that a different question? Sure, you're entitled to sort of come back with that.
I think within Judge Gaziano's discretion, it was proper, and also the defendant had the burden to show that this was admissible. He had the burden to show, as he argued, it was admissible for prior recorded testimony.
Is that the only basis on which he argued it was admissible?
Yes.
The only basis?
Yes. And then the defendant's argument that he sought to introduce it for impeachment, there's just no indication on the record that he did that.
Why else wouldn't he be, I mean, why else would it be introduced? It is impeachment. I mean, that's the whole purpose of it.
Correct, but I think impeachment wouldn't be admitted for substantive purposes. There are two different purposes for admitting them, and the defendant never proffered it. And we're looking at abuse of discretion here, and I don't think there rightly could be an abuse of discretion when the judge isn't asked to exercise that discretion. And I do think that from the record, it's obvious that this was probably a strategic and properly strategic decision not to introduce this, because
not to introduce what? Excuse me.
To not try to introduce it for impeachment, because I think that it's a very experienced defense counsel, and he would have known that the Commonwealth would have been able to rebut this with everything from the grand jury proving this misidentification's falsity. So I think for that fact alone that it wasn't sought to be introduced for any other purpose except prior recorded testimony. And then moving on to the gang video,
But wouldn't that have the same, wouldn't the Commonwealth be able to rebut that too? I mean,
Yes.
so why would one be a strategic decision and the other not? If he wants to get it in front of the jury in the one instance, and then you're saying it's strategic for him not to get it in front of the jury in the other for impeachment grounds, because the Commonwealth could rebut it, but the Commonwealth could do that in either case.
correct, and I think the defendant's arguing that he sought impeachment later on in trial, and I can't exactly speculate why, but I do think it would be reasoned strategy to not seek this in, because the Commonwealth would be able to rebut it. And regarding the rap video that the Commonwealth introduced, Judge Gaziano did properly exercise his discretion in admitting this in order to rebut evidence that was brought out on cross-examination of Sergeant Duggan that the defendant was essentially not a gang member at the time of this murder.
So that was the essence of the cross-examination, that he was not a gang member?
The cross-examination was showing the defendant's photo from the Boston Police Department gang database, and then the photo that was taken of him when he was arrested for Herman Taylor's murder. And they're the same photo. So the question was essentially, is the photo in the database the photo from the day he was arrested? And then after cross-examination, there was a sidebar where the prosecutor argued and the judge agreed that there was a very clear inference that could be made that the jury could infer that the defendant was not in this gang database and thus not considered a gang member until he was arrested for this murder in 2007.
Hadn't defendant or defense counsel conceded that the defendant was a gang member?
He had in his opening statements, but I remember this is the Commonwealth's burden to prove its case, and once the defendant started rebutting or challenging the Commonwealth's motive, it had every right to introduce more evidence of that. And this tape was particularly probative because what was important was that the defendant was in the gang on the day of the murder, July 12, 2006. And this video was pulled from the internet in 2005 that Sergeant Duggan testified to. So the purpose of it essentially was to show that he was in a gang prior.
Did the video establish that he was in the gang?
I think it did. When you look at it compared to Detective Sheehan's testimony, Detective Sheehan was the Commonwealth's gang expert here, and he testified that Heath Street is known as the Heat, and that they frequently wear the colors of the Miami Heat basketball team.
as being in a video doesn't necessarily mean you're in a gang, does it?
It doesn't necessarily on its own, but I think you have to take the defendant's argument with a grain of salt that being in a gang and creating music videos can never mean the same thing. I think here the fact that he was in this video with wearing red bandanas, which several other people are wearing red colors, which are the Miami Heat basketball team colors, rapping about the Heat and Heat life, and it's the Heat until I'm gone, in conjunction with Detective Sheehan's expert testimony that Heath Street is known as the Heat and that they wear the colors of the Miami Heat basketball team, and the defendant's featured prominently in this video. I think it does rebut, and the video was created at least in 2005, if not earlier, goes to help bolster the Commonwealth's motive that the defendant was a gang member in 2006. And I think...
Not just a performer.
Correct. That it goes to show that he was he was in a video singing about essentially being in Heath Street. And when you look at that compared to also...
So if there's a band singing about, and bands can sing about anything, they sing about lots of things that maybe don't relate to their personal involvement in anything. So if they sing about something, then the drummer in the band is undoubtedly part of the something they're singing about?
I think this goes to the weight of the evidence for the jury and how they factor it in and how they consider it. But you also have the testimony of Shagar Williams, Sergeant Duggan, and Detective Sheehan being the expert, all opining that the defendant was in the gang. But their testimony wasn't necessarily he was in the gang at this time of the murder. Detective Sheehan's testimony as the expert was just going through everything I've reviewed. He was a Heath Street member, is a Heath Street member, and Shagar Williams testifies that he was a Heath Street member.
So, I mean, one of the things we've got to look at is the extremely prejudicial nature of the video itself, right? And that, I mean, you have to admit that that's artistic in the sense that's a type of music which has a lot of violence, references to violence in it. That's a genre of music. So that's instantly going to mean a lot more than, geez, he's wearing the colors in in a drum major presentation. I mean, this is something very violent. This is a violent crime. So the potential for prejudice is enormous here.
Of course,
Could they just have done a picture one still of him singing with this group?
I don't think so, because also the lyrics were important, that they're rapping about the heat and heat life, and it's the heat until I'm gone. So those in combination with him wearing the red bandana, which several members in the video are wearing either red bandanas and or red hats.
It could have been limited to that, like a redaction, right? Just focus. But if that's the only significance, it could have been limited to just that piece.
Correct, but I think the Commonwealth was allowed to put in the whole video, and I think, of course, evidence of gang evidence is always going to be prejudicial, but I think the jurors could also, in their common knowledge and common experience, could understand that there is some exaggeration in music. As one of your honors asked earlier, a layperson could interpret the song lyrics without needing an expert. I think it's more introduced for the purpose that he was in a gang in 2005 and proclaiming his membership.
Would you agree rap music is more, I don't know, aggressive than a lot of music?
I disagree with that characterization. I think there's several types of music that could be interpreted as offensive to other people. But I think here also the defendant's representation that this was a majority white, all middle class jury, that this would be particularly offensive to them is completely unfounded. There's no indication on the record anywhere anyone's race or socioeconomic status. So the fact that there's this hypothetical all-white middle-class jury is just unfounded. And I think it's the exact opposite, because it was a very experienced trial defense lawyer, and I do think he would have raised that issue at trial.
I take it there was an objection
The
to the video.
makeup of the jury.
Yes.
Oh, I'm sorry, the makeup of the jury.
Oh, I'm sorry,
I
yes.
take it there was an objection to the video coming in evidence at trial.
Right, but not to the makeup of the jury.
So if they were rapping about life in prison, would that be evidence that they actually had been in prison?
I don't think so necessarily. And I think here the main reason for introducing this tape was to show that in 2005, the defendant was a member of a gang. And this was also slightly cumulative of his gang membership was also slightly cumulative of Detective Sheehan's, Sergeant Duggan's, and Shagar Williams' testimony that the defendant was a gang member. So even if this video shouldn't have been played, which I obviously don't concede, there could have been no prejudice to the defendant. And essentially, by the defendant's essentially challenging that the gang evidence shouldn't have come in because it wasn't a strong enough correlation to the motive here. And I think just looking at the record, that's incorrect. We have here the fact that the defendant was a member of Heath Street and that there was a gang feud. Several people testified to the feud between H Block and Heath Street, including our expert who testified that there was a pattern of violence between April 2005 through July 2006, that 99% of these crimes were firearm crimes, and that they usually occurred in rival territory, and that there were several non-gang victims. And there was even evidence of a feud, which logically there can evidence of a truce, and there logically can be no truce without a feud. And then if you look at the facts of that day, we have the defendant riding around with a known gang member, a known Heath Street member, Roosevelt Wilkins. They circle rival territory 3 times. They circle H Block 3 times. And the defendant gets out of the car, goes up to a young black man, argues with him, and this young black man looks terrified even before the defendant pulls a gun. And then while that's happening, the car full of people, including Jameson and Williams, drive by. Jameson, as a known H Block member, gets very upset and very animated when he sees a Heath Street member in his territory, and then demands to get out of the car and run over to them. And it's so concerning to Shagar Williams, who's Chris Jameson's girlfriend and has also dated a Heath Street member as well, is so afraid that Chris Jameson will get hurt or someone will get hurt because the defendant is there in rival territory, that she doesn't let him get out of the car for a while. I think all these facts together show that there was a strong motive because of this gang feud. And if there are no further questions, the Commonwealth rests on its brief.
Thank you.